SJC-11693, Commonwealth v. Sheldon Mattis.
Okay, Attorney Schiff, whenever you're ready.
Thank you. Good morning, and may it please the court. I'm Ryan Schiff, and I'm here on behalf of Sheldon Mattis. With me are Ruth Greenberg and Paul Rudof. I'd like to begin by addressing Justice Lowy's questions about why 21 should be the cutoff.
To be specific, why the court should consider 21 as the cutoff, because there's all sorts of reasons, darn good reasons for your position about 18 to 20-year-olds. Very good arguments that were well made. It's not whether they should be parole eligible, it's whether the court should decide whether they should be parole eligible because it's a constitutional issue.
Correct, Your Honor. So the place where we think the court should look for a model of the kind of analysis is to the Supreme Court's decision in Roper. And the reason we think that is most relevant, there are two reasons. The first reason is that in that case, as in this case, the court was looking at whether it should raise the age. In Thompson versus Oklahoma in 1988, the Supreme Court said that the death penalty was unconstitutional for those under the age of 16. So in Roper, the court was in the same position as this court, deciding whether it should raise that age to 18. And then the second is that this whole line of cases, from Roper to Graham to Miller to Diachenko, all use 18 without any analysis of why. And Roper is the only case that actually looks at why that should be. And the Roper decision looked at two things. First, it said that 18 is appropriate because it is, quote, the point where society draws a line for many purposes between childhood and adulthood. So that's where we look. And then the court looked to whether the logic of Thompson, its 1988 case about those under the age of 16, applied equally to those under the age of 18. And that's exactly the analysis we think you should do here. When John Adams helped set the groundwork for the formation of the Boston Bar Association, an organization that supported us in an amicus brief, he and every other lawyer in Boston would have understood, just as Blackstone understood, that 21 was the age of majority. And that continued to be the age of majority well into the 20th century.
I'm surprised you're focused this way because, to me, Diachenko supports the result you want, but this starts to sound like just what Justice Lowy is concerned about, which is policy choices. I mean, if it's being driven by science, that's different than if it's being driven by a policy choice of when you're an adult, because that's what the legislature does.
So I don't think it's a policy choice. I think what we're doing is we're looking at two things. One is that you're making this decision, as you said in Diachenko, with the science in mind. Mm-hmm. So it is a decision that is informed by science, but is not ultimately, it's a legal determination. It's not, you're not deferring to science for the answer. And I think the reason that we're looking at this long tradition of setting 21 is for the same reason that the court did in Roper. We're looking to these kind of societal norms and then applying the science to that. And that does a couple things. One, it avoids some of these concerns of the Essex County District Attorney's Office about a possible slippery slope, because we have something we're looking to. And it's something that's firmly grounded in our society's understanding.
As to the third Seppellonis point on proportionality,
yes.
Would your position, as far as a hard stop on 21, be supported by the 25 states who don't allow for juveniles to be convicted of first-degree murder?
I think that's a good question. I think it does. I don't think this court's case law has not done the kind of head counting that the Supreme Court has done counting other, and I think for good reason, that you independently interpret your Article 26.
But
And-
the third prong of Appellant, by memory, at least looks to other jurisdictions.
That is true. I think the more relevant thing to look to, though, is the growing consensus, and certainly the consensus in Massachusetts, that Judge Ullman's findings were correct, that late adolescents are different than other adults in very important ways that are relevant to sentencing.
He also had a lot of caveats, didn't he, about some of his finding, about the whole conclusion?
He did.
He listed a bunch of things that
So
were a problem.
I don't know if they're problems. He did talk about these as caveats. I don't know. I would use the same language.
He thought there was a difference between the subject and the study
Correct.
in the prisons and in the studies, that they weren't randomized, that there's difference in individual brain development versus groups when you look at them that way, that the situation was different, which I guess is your cold and your hot, and that it was only a correlation, not a causation. And then finally, I think he said that there were problems in some of the original studies, right? So he said there were some, that some of the pre-2013 studies had some problems with their machines.
I'll try to address some of those individual concerns. The global answer to that is the one that he said, which is that most of these are just sorts of issues that are true about any kind of science, and they're not unique to this particular science, and I think he was right to say that, but I do want to address some of these individual concerns. So the issue with the machines was that it was the way statistical analysis was done with MRI prior to 2013. The studies that are being relied on here, the most important ones, are post-2013, and the findings in pre-2013 studies have been, well, he said, like, not replicated in that they did the exact same study. Similar studies have been done and have found the same kind of results. Now, in terms of the correlation versus causation, these are correlational studies, but they're not weaker studies. Every medical study that's done to figure out what a good treatment is for any particular disease is a correlational study. You have two groups, you give the treatment to one, you don't give it to the other, and you see that those people get better. That's correlation. And that's what we have here, where they look at the brain. This is true of the fMRI, not the structural MRI, to get a little bit into the weeds studies. Yeah. But with the fMRI studies, you expose the person to a particular stimuli, then you look at the scan and you see that this part of the brain is lighting up. Do we know that that means that is, or is this causation? No, but it's correlation. You do X and Y happens, and we can't do causation studies with living subjects with their brains. That would be unethical. Now, I do want to address the issue of real world. This is laboratory stuff, so what about the real world? And this is one of the great things about the record in this case, and I think why you were right to send this back for creation of the record. Last 2 years have shown us, as we've dug into this science, how much more robust our understanding, and I hope the understanding we've been able to bring to the court is about what this science actually shows. And if there's one thing that's important, it's that this isn't one field of study that we're relying on. Instead, there's a convergence of evidence from multiple scientific disciplines, and for this point, most importantly, real-world data. So we look at real-world data for crime statistics and also other kinds of risky behaviors in late adolescence. And what we see is that the stuff that we would expect to see from the laboratory studies actually is true in the real world. There's something called the age crime curve that shows that as adolescents, as we see, this is group data, but as people move into adolescence, crime starts to take off and they commit a lot more crimes. That then peaks out sometime in late adolescence and then drops off. Exactly what we would expect to see from the laboratory studies looking at the brains and looking at behavior through developmental psychology.
Isn't that true of 21-year-olds too, though?
Is that true of 21-year-olds? So the age crime curve probably starts to drop off a little bit early, but this is the importance of what I was talking about before when I was talking about the common law understanding. But it's not only the common law understanding of the age of majority. So then with the record, there's been great scholarship, and this was cited by the Washington Supreme Court, of where our age of majority comes from. And what it shows is that Blackstone said that the age of majority was 21. the founding, the age was 21, and it continued to be for
Yeah, but they also had an age of consent at like 10 in some states, so we can't really rely on that, can we?
So, but let me, if I may, the important thing about that is that we then see that continuing into the 20th century, and then around World War II, there's a need for soldiers, so the age of majority lowers so that we can have people to go fight the war.
But again, isn't that that's a legislative judgment? That's, I understand driving, the science driving things, but I don't understand, okay, the legislature keeps changing its mind. You could drink at 18, now you can drink at 21, You could be a soldier when we needed you in World War II, but those are policy calls. I'm just worried that you're straying into something that Diachenko wasn't relying on, and you're looking at a Supreme Court jurisprudence that allows just what Ms. Campbell's about to argue, which is this individualized inquiry. It just seems like you're getting to the wrong spot here.
Well, I do think that you need to look to this.
Not
I absolutely understand. I do think we need to look to the science, and the science needs to, I don't know if drive is the right word, but certainly inform every step of this analysis. But for these kinds of, and maybe this is a way also of addressing some of your concerns, Justice Lowy, about sepulonis. So the body of case law that this is based on is case law that came about after 1982 when sepulonis was decided. These are categorical bars, originally on the death penalty, but for very serious punishments. And for those kinds of categorical bars, two things are important. One, and this relates to the sepulonis factors, is that for these this is the most serious offense. I'm not shying away from that. And our argument, just as this court made clear in Diachenko, is not that there's disproportionality between the offense and the punishment, or rather between the offender and the punishment, and that's different than the issue that was before the court in sepulonis and those cases that have strictly applied the sepulonis factors. So I think we should look to Diachenko for that kind of analysis.
So so does Diachenko modify that? Because if you apply the sepulonis factors, the first factor, and again, I defer to Justice Lowy, but the first factor is the crime, right? How serious it is, and this is first-degree murder. When we look around the country, we're way ahead of everyone else, so that factor also cuts against you. Mm-hmm. If Diachenko isn't converting this into a science-based analysis, you've got an uphill climb, don't you?
So I'm happy to have you decide this is a science issue because I think we absolutely win. The reason that I'm looking to the societal norms is because that gives you a way of saying, well, what is that number? And this is the thing about these categorical rules, is that there does need to be a definition of what category it applies to. So,
but that's not what Diachenko did the opposite, right? It didn't try to put a cap. It left it open, and I'm surprised because I suspect in 2 years we're going to have 23-year-olds. You're going to be back doing the 23-year-old argument.
Well, I certainly won't be back making the same argument, and I won't be back, I don't think, because I think it's a harder argument to make for a 23-year-old for
But it
exactly...
wouldn't be after we decided this case if we went in your favor.
I'm sorry?
It wouldn't be that hard if you win today.
So here's why I think 21 is really important. Mm-hmm. So after World War II, goes to 18. Then about 40 years later, we start to see the problems with having it 18. In 1980s, President Reagan sets up a presidential commission to look at traffic fatalities, and they find that if we raise the drinking age to 21, guess what? We're going to reduce the traffic fatalities, and they set 21 as the age for purchasing alcohol across the United States. In Massachusetts, when the age for having a license to carry a firearm was raised, it was from 18 to not 22, not 20, 21. When
how much science?
So you're saying we should raise the age for homicide? I mean, I don't understand.
No. This is solely
Yeah,
you
it's
can
just
sentence people to life.
Right.
It's just whether they have parole consideration. What I'm saying is that just like the court did in Roper, you look to these commonplace. Where is the distinction between adulthood and childhood set for many purposes, and it is just not true that that is solely 18. It's also not true that it's 22 or it's 20. 21 was the common law age. 21 it's not arbitrary that when all of these ages have been raised or set for marijuana, for casino gambling, it was set at 21. That's not a mistake. That's a return to the common law. And by setting it 21, you have a principled reason for doing it based in this long tradition of setting 21 as a cutoff between adulthood and childhood. And you also are firmly rooted in the science in a way that 18 is not. The science does not support keeping it at 18, but it does support keeping it at 21. If I may, I do want to return to the Sepulonis issue.
Sepulonis, by the way, in complete candor, science is part of step one of Sepulonis and how it applies to the particular offender. It's part of the 3 steps.
That's absolutely correct. That was the first thing I was going to say, is that the kinds of concerns that we're raising here are built into the Sepulonis factor. It's the first factor asks us to look not only at the offense, but also at the offender. But I think the reason why we need to be very careful about applying that in the same way that you might in some other contexts is that we can look at Diachenko's case. And interestingly, back in 1982, when he was on direct appeal, he raised an Article 26 challenge to his life without parole sentence, the same one that he later brought in 2012-13. And at that time, the court rejected that challenge, applying strictly the Sepulonis factors, and said he was convicted of murder. There's nothing more serious than
Also
this.
twice rejected this issue, and then in Watt said, basically, given the passage of time, maybe it's time for a second look, correct?
Correct, and I think that was, I think you were right to do it the way you did, which was not to just decide this based on, amicus briefs setting out the science, but actually send it back for development of the record. We now have before the court the testimony of Adriana Galvan, one of the leading neuroscientists in the world, runs the UCLA Developmental Neuroscience Lab. Larry Steinberg, probably the world's leading developmental psychologist studying adolescence. Robert Kinscherf, who is Massachusetts' leading forensic psychologist looking at issues of adolescence. And then Stephen Morse, the Commonwealth expert, who is the world's leading neuroskeptic, the person who says, hold on, maybe we shouldn't use neuroscience as much. And you have the testimony of all of these people. And there, as Judge Ullman found, there is no real dispute about ultimately what the science shows, and that's that development continues past the age of 18.
But it continues all our life in some way, doesn't it?
Yeah, absolutely. Development changes, and we change throughout life. But the 3 characteristics, as this court defined them, that were of constitutional significance in Diachenko, those are present during that time. And the first one of those, so the way the court talked about them was less the way science necessarily talks about them and more in terms of justifications for sentences. And I think this goes to the issue of hot-cold cognition and sensation seeking. These both fit into that first concern about culpability, but they're 2 different things. And what the studies have shown is that late adolescents, when their reward systems in their brain go off, that leads to greater sensation seeking, not only than older adults, but also than the younger adolescents who are at issue in Diachenko.
So in some ways, as I was questioning your opposing counsel before, that sensation-seeking science indicates that this particular age cohort is actually less able to control themselves than the so-called juveniles.
That's absolutely correct. And that this is a more vulnerable age than the younger juveniles in many ways, because that sensation seeking then leads to criminality. It also leads to seeking out peers, which then increases their risk taking and probably puts them in situations where they're going to be relying on hot cognition more. So all of this feeds into
Why
it.
are we limiting this to life sentences then?
You're limiting this to the life sentences because that line of cases that I was talking about before, those categorical rules, have only ever been applied to life sentences and the death penalty, which is a unique, as you correctly found in Diachenko.
This will raise Perez issues
Exactly.
going forward, right?
Correct. I do agree that Perez would apply. I was trying to think through what are the additional,
So someone that was convicted of an armed robbery who got a 20-year sentence could come back and say it's disproportionate under Robinson Mattis.
I think that, so the three cases that I could come up with that would have implications are Perez, Costa, and then Diachenko too, those kinds of.
That's down the road.
I'm sorry?
That's down the road.
It's down the road, right?
It is-
But the 18 to 20 on a child sexual assault case has to be, with a juvenile, 18 to 20-year-old, we're going to have a Perez, there has to be a Perez analysis.
I do think that's true. You know, I don't represent somebody in that situation, so I think you should decide that when that case comes before the court, but in candor, I do think it would apply. Now, in the juvenile, our experience with Perez has said that has not actually turned out to be all that many cases for juveniles, and I think there have been fewer than half a dozen Perez hearings. So the number of Perez hearings that would have to be held, even with this group where there is.
Well, given the crime curve, I think there'd be a lot.
Well, there'd be more. I don't have
That's why
that
the-
number.
that's
I
why
don't
the
have.
number of murder cases, or first-degree murder cases for 18 to 20-year-olds, I assume, far exceeds the number of murder cases for juveniles.
It is significantly more. You know, as of October of last year, it was 203 cases that would be impacted by this. I believe there were about 80 Diachenko cases.
Right.
So there'd be more, but I don't think it's going to be overwhelming the number of Perez resentencings there would be. And I think we have to also remember,
Well,
those
I
are
mean,
people.
we have an Article 26 duty anyway, so that's.
I think that's right. And those are people who got really long sentences without these important issues being taken into account. So I don't think it's a bad thing that they would get this constitutional remedy. And I think it would be a small enough number of cases that wouldn't create any kind of undue burden on the courts. If I may, I would like to address just one issue that came up earlier, and this is this distinction between soft and hard science. I respectfully disagree that any of this is soft science. Dr. Steinberg testified a little bit about this, that this distinction is kind of an artificial distinction. But certainly the science that we're talking is about, using sophisticated technologies to look at living brains and conduct sophisticated statistical analysis of those results, and then also to have these very carefully planned out developmental psychology studies, including the one that involved 5,000 subjects and was, as large a study as I've ever seen in any field, looking at these things in very sophisticated ways, and I don't think there's anything soft about that. And there's also nothing soft about when criminologists look at FBI crime data and make these kinds of determinations that have been made across societies for more than 100 years, and see that the age crime curve is a real thing that exists across cultures. You have before you 6 amicus briefs, and 5 of those support our position. And they lay out some very important concerns, including from scientists, from retired judges, from juvenile justice organizations, from racial justice organizations. But I think perhaps the most important thing that you have before you from amici is in the last few pages of the CPCS brief. And there you hear about 3 of the 203 people who will be impacted by your decision in this case. And those 3 men who are in their 40s, 60s, and 70s not only have proven that these people who commit these kinds of serious crimes at this age are capable of rehabilitation, but that they're capable of truly transforming themselves into extraordinary people who've already given back to their society from inside prison and have so much more to give back outside of prison. And we're not asking you to release anybody from prison. All we're asking is that rather than throwing away the key, you place that key under the careful guard of the parole board. If there are no further questions, I'll rest of my brief.
Thank you.
Thank you.
Okay. Attorney Campbell, once again.
Thank you. And just for the record, Cailin Campbell appearing as a Special Assistant District Attorney on behalf of Suffolk County. With me again is A.D.A. John Verner, who is the motion prosecutor. I would also like to acknowledge I'm in the rare position of there is disagreement amongst the district attorneys. Essex filed an amicus, and Plymouth County joined that as well, urging that the sentence be declared constitutional. And so I think it's important to just mention that before I start. I'd like to go back to your question, Justice Kafker, about this individualized sentencing hearing and the science in the individualized sentencing hearing. And I think that's just one part of it. Even if you look at Miller, if you look at the factors, and there would be similar factors that would be considered in an individualized sentencing hearing in this instance, but they do talk about the science, including age, immaturity, impetuosity, I can't say that word, failure to appreciate risk and consequences, but there are other factors that the judge would look at as well. And I think that would make it more like an individualized sentencing hearing that judges engage in every day.
I understand that, except for I can't reconcile it with Diachenko. Because it seems to me that the science has just moved the problem from under 18 to 20 here. So I can't get to your result. You got to help me get to where you want to get, because Diachenko is the case right on point.
Correct.
And it's so analogous, and it just seems like the science has moved. So I don't understand how I can come to your result consistent with Diachenko. But go ahead.
Counsel,
Certainly.
before you answer that, can I ask you to address one other aspect of that?
Yep.
When we just heard from the presentation that even with the Commonwealth expert, there isn't any disagreement about the underlying science. I mean, the vast majority of it. So it would seem if you're advocating for a Miller-like hearing for 18 to 21-year-olds, you've got to tell us where the science diverges in order to support that. And I know you made some individualized references the last time you were up to certain things, particularly when you were talking about the sensation-seeking and what prompts that. But really, could you tell us, if we get to where you're asking, you've got to tell us that the science is different, wouldn't you?
Certainly. Two different questions. I'll start with Justice George's question.
Absolutely.
Okay. And so I think that there is agreement. So I disagree with what my brother said, that there's an absolute consensus. I think there is an agreement that the brain is maturing during this point, but I think there's disagreement as to what that maturation point is. And I think there's disagreement, and specifically, largely this can be found on pages 36 and 37 of my brief, but specifically, I would say that the difference is that different brain functions mature at different rates. For example, cognitive capacity reaches an adult level prior to psychosocial maturity. I think that's important when you're thinking about murder, and murder is a unique crime in the different ways it can be committed, and murder is a unique crime. If you look at specifically first-degree murder, there really is a difference between a deliberate premeditated murder as opposed to an extreme atrocity or cruelty as opposed to a felony murder. These factors definitely come into play if you're looking at the type of murder, the type of cognition, the type of planning that would need to come into play, the type of specifically...
Scientists and lawyers talk in different terms. I mean, I understand that premeditation can happen quickly, but I'm not sure that's the same thing as cold cognition.
But I would say Dr. Kinscherf, and this can be found at pages 113 and 114 of his testimony, explained that a murder that was planned over a period of time, or an individual who commits a murder and uses thoughtful means to evade detection, would be committed in cold cognition. So there was a recognition from at least Dr. Kinscherf, and there was a consensus that a murder could be committed in cold cognition.
I understand that you focused on that point in your brief as justifying this, but there are other things that there is consensus on, which is that the brain is continually maturing. And doesn't that go to this incorrigible depravity issue? There seems to be a consensus that these 18 to 20-year-olds can make this kind of leap to maturity, even if they've done something heinous in a premeditated way when they were 18 or 19 years old.
Certainly. So I think the answer to that is but one factor, right? That is,
Always, there's a consensus, again, you correct me if I'm misstating the science, because I don't fully understand the science.
Okay.
But from what I understand from the record, is there's a consensus that even that there's this potential redemption quality out there, even for the people who've committed these heinous premeditated crimes, that's in the, and that you haven't sort of gotten around. And then I feel for this poor trial judge, if that's the case, how is this trial judge going to do this individualized inquiry? I understand the Supreme Court's telling them to do that.
correct.
But we've not under Article 26.
Correct.
We've created a more protective environment.
So I think in terms of the record, I think here's my answer to that. You can't say with any certainty that a 20-year-old as opposed to a 19-year-old as to an 18-year-old necessarily has not fully matured. All of the experts agreed that there was a difference in variation of maturity of individuals.
They also say you can't make that determination who is and who isn't.
Correct. I would say if you look at the actual...
They can't. How can the trial judge?
Correct. I think, though, if you look at the phrase irretrievable depravity and sort of its evolution, it's first articulated in Roper in 2005. And in Roper, and this can be specifically found at page 570, they say, the reality that juveniles still struggle to define their identity means it is less supportable to conclude that even a heinous crime committed by a juvenile is evidence of irretrievably depraved character. And then they go on to talk about how the signature qualities of youth are transient, so that's why you can't draw that conclusion. It's repeated again in Graham, and this is specifically at page 76, and in Graham, they articulate that you can't just look to the facts of the crime itself to conclude that there is irretrievable depravity. That language, the first time it appears in Massachusetts is in Diachenko. And in Diachenko, well, it's in Miller, but it's interesting, it's not in the majority opinion in Miller, it's in a concurrence in Miller where they're discussing it in the felony murder context, how a felony murder wouldn't be evidence of that. The first appearance of it in Massachusetts is in Diachenko. They cite back to Roper, and they say, simply put, the brain of a juvenile is not fully developed either structurally or functionally by the age of 18, and a judge could not find with confidence that a particular offender at that point in time is irretrievably depraved. I think it has to do with those transient qualities of youth, which you can't look at just the facts of the crime itself, correct? But I think you could look at a confluence of factors, as the judge is asked to do in many individualized sentencing hearing, and saying not just the facts of this crime, not just how it was committed, but things about this defendant, which of course, in an individualized sentencing hearing, a judge would hear things about this individual's life that now they don't with a mandatory sentence here.
It seems like this is core Diachenko, that taking that responsibility away from trial judges because the person's not yet fully formed and putting it on the parole board 15, 20 years later. So I don't get how, given the history of that, as you well stated, of that phrase, we have to deal with Diachenko and the Diachenko remedy. And what we've already said in the past, it's not for the trial judge, it's for the parole board.
I think, and that's where the difference is in the record, and I'm not doing a good job of explaining what those differences are, in part because it's so complicated and voluminous. But if you look at the differences in the record as it relates to those under 18, and that sort of categorically the experts agree that those transient qualities of youth are more uniform across the board, that applies to those under 18, so that applies to Diachenko. When you get to 18, 19, and 20, yes, the record shows that the brain is still developing, but it shows that these individuals are more capable of making mature decisions, that these individuals, there is a variance in the rate with which they mature, and that these individuals in very relevant circumstances can have a brain and make decisions that is functioning like an adult. I think it's because those key differences exist that it makes it different from Diachenko. Now, the Commonwealth is not saying...
Are those key differences significant enough to not have a Diachenko remedy, though? I mean, I suppose if you say that statistically there's got to be some number that's not going to fit, right? There's got to be some, but if we're looking to doing something constitutional, forget about the unicorns and the lightning that occasionally strikes. Isn't the vast majority of these folks are being able to say, we just can't principally define or delineate the line?
You know, that's a good question, and I think that if we weren't talking about first-degree murder and we weren't talking about the most serious offense that could happen in the Commonwealth of Massachusetts or anywhere, my answer might be different. I think the problem is any proportionality test has to view not just the nature of offender, but the harm it has to society and the harm that it has on a victim. And I think, as often happens in these type of crimes where there is a victim, there isn't enough focus on the harm that has happened to them. And the crime in this case has caused an irretrievable harm to both the victim, but to their...
Talk about that for a minute, because I honestly don't get why it wouldn't be a Diachenko hearing if we're going to say 18 to 20. It seems to me that Diachenko does speak to that. But Sepulonus, step one, takes into account the harm to society.
It does.
And Graham, Florida versus Graham, recognizes that it's an arbitrary number and that the brain continues to develop after 18. But what is it about, and then Roper recognizes, no, we're just picking
18.
18, we're picking a number because that's societal norms, right?
Correct.
So what is it about Diachenko specifically that says the delineation isn't, we're talking about juveniles here? Where's that in Diachenko?
I think it's because Diachenko, so explicitly does it say that? No, I don't think so, but I think if you look at what the court was focused on Diachenko, which was the science, and if you look at what the remand in this case is, which is the science, that's how you get there.
Science is important.
The science is important.
No one's saying that.
I think that there is actually an answer to the law as to this differentiation, because it's interesting because, as been discussed in both arguments, it's not a clean age of majority. There's not a consistent history of an age of a majority. Even now, there's some things that are 18, there's some things that are 21. So there is a recognition that there is a variance among this age group. And there is a variance as to 18 and 21 in levels of maturity. So I think even looking at that sort of legislatively, is it a legislative question? Yes, there is support that there is both 18 to 21, and there is something about this group and that cohort and that age.
Delineation that you say isn't clean, when you can be on jury duty, for instance, when you can vote, that line moves depending on the policy. You're 18 and over, you're an adult. There's all sorts of legislation suggesting that should move.
Correct.
And, you know,
Correct.
Roper, I mean, my gosh, putting aside all the horrors of the death penalty, who wants to see 19 and 20-year-olds be put to death? That's not what they're analyzing. They're analyzing that there is a number and that social norm is X. I think it's a fascinating debate to see if that social norm is 18 or 21. But why is that not legislative?
I think insofar, you know, the traditional Commonwealth argument would be it absolutely is legislative. This is a question for the legislature. That's where you leave it. I think the record here shows that there is, if you're really talking about proportionality and you're really looking at the nature of the offender, the record here is developed enough that it does show that in ways that it relates to culpability, there is enough in this record to say, okay, maybe this subset of people have a lesser culpability than those over 21. So that's what I would draw to. Now, it could be that there is also consensus in the record that they are more mature and more capable of making better decisions than those under 18. So that's where that differentiation comes, and that's why the Commonwealth has proposed the I guess I would call it intermediate suggestion that we have, which is to treat this subset of group of people, recognize that they do have some similarities with those under 18, but they are a maturing group, and that an individualized sentencing hearing would be a constitutional and proportionate way to deal with sentencing this group of individuals. I am over, and so unless there are no further questions, the Commonwealth will rest on its brief.